Hi everybody, welcome back to Law Hero. My name is Jen and I make videos about the law. And today we're looking at precedent or stare decisis. And this is a principle of Irish law that is very, very important and also has many commercial implications. So that's what we're looking at today. And this is largely based on the chapter with the same name in Burnham McCutcheon, which I'll be looking at today. So to set a precedent in usual parlance means that there is a benchmark or so a common set of rules that is relied upon for certainty. And indeed the authors start off the chapter by saying that looking for guidance for current practice from past events is very common. Like children will say to their parents, everybody's going to the football match except me. It's like attracts like. And it's very important also for commercial actors because you're looking for certainty in the environment in which you operate. And to seek consistency, two objectives of justice are pursued. The first is that the law is equally applied or similar cases are treated similarly. The second is that the law becomes predictable. And in public law, this is called legitimate expectation, and it all comes within the broader principle of the rule of law, legal certainty, and ultimately a democratic state. If courts were afforded discretion as to whether to follow an earlier case or not, there would be a lot of chaos. That's not to say that judges don't show their discretion in certain cases. Certainly there has been lots of debate around sentencing in Ireland, around the levels of quantum in personal injury cases. And also I read during COVID Noise by Daniel Kahneman, and he had a full chapter in that book which looked at decision making. He had a full chapter in that book around judges' decision making in particular, and he found some crazy reasons around decisions. For example, if decisions were made at the start of the day, at the end of the day, after lunch, depending on like if a judge's favorite football team had won. Crazy stuff, but it is part of being human. So just to be clear as well, civil law systems do adopt precedent, but it's more important in the common law system because of how it was built up, and because of the kings and the queens, and the lack of kind of comprehensive codes like in France and Germany, for example. In order to have precedent, you need to have some sort of ranking system, and this occurs with a hierarchy of a court system. For example, like Supreme Court judgment overrules a High Court and a Court of Appeal. Let's actually look at the system. So once two cases are placed in the same category and thus considered to be similar, the expectation that earlier cases be followed strives to ensure consistency in the application of law. So when, for example, you do your exams and you're in the application part of answering your question, you will say something like, in applying the law to the facts, you could say these facts are similar to the case of X, but distinguishing the case on the facts, i.e. some of the facts are different to that case that was in court. Like that would be a good way of approaching it, or saying some parts of the case are irrelevant towards that case. And what you're doing is comparing and contrasting, and that's what judges do. They look for similarities and differences in the different cases. And that's what the methodology is in precedent. So a distinction is drawn between binding authority and persuasive authority. A court has to follow a binding authority, but it doesn't have to follow a persuasive authority. The principal rule which has emerged that a court must follow prior decisions of courts superior to it in the judicial hierarchy. The rule is so well established it has barely ever been questioned in this jurisdiction. That's interesting. A court is not bound by decisions of an inferior court. Likewise, Irish courts are not bound by decisions of foreign courts that would be inconsistent with Irish sovereignty. When a court is said to be bound by an earlier decision, it does not follow that everything which the earlier court said is binding. Judges do not adopt a uniform format when writing their judgments, but a number of elements may be identified in each judgment. The part of the judgment that is binding is called the ratio decidendi. For present purposes, it can be defined as the reason for the decision. It consists of the principle of law applied to the facts of the case. Other statements which are contained in the judgment are called the obiter dicta. They are not of direct relevance to that decision and consequently are not binding, but they may be persuasive and therefore useful. When an appeal is successful to an appellate court, it is said to have reversed the inferior court. The effect is that the decision of the lower court is replaced by that of the higher court. Say, for example, an appeal from district to circuit, and then on circuit is reversed. And the party who initially lost the case now find that they have won. However, once a decision becomes final and is no longer can it be appealed, the principle of res judicata applies, and the parties are bound by the decision and may not seek to have it reopened. Although some people go to Europe, for example. When an appellate court, but that's only on a point of, that is only on a point of law that is relevant to EU law. When an appellate court in a later case considers the earlier decision of a lower court to be erroneous, it may overrule that decision. Courts do not often overrule decisions of courts of coordinate jurisdiction. They prefer to distinguish them. In some cases, a court might have reached a decision in ignorance of a relevant statutory provision or binding authority. In that event, the decision is said to have been reached per incuriam, which means through lack of due regard to the law or facts. That's cool. A difference of judicial opinion is evident on the question of a judge considering a point which was not specifically addressed in counsel's argument. Okay, so we're going to make one further point, is that ratio decidendi is based on the facts of the case. So what does that mean? That's because courts decide on factual scenarios, not moot or abstract ideals. And that is why the ratio decidendi is based on the facts of the case rather than any hypothetical set of circumstances. It is the rule which was applied as limited by those facts. A court's decision of the case is normally confined to the actual facts, and a decision by its nature concerns those facts and no others. So it basically means that it's on a case-by-case basis on the merits of that case. However, to read cases in such a narrow manner would be destructive and destroy the stare decisis system. No two cases are alike, and in consequence, no decision will be binding. Realise that facts can be stated at different levels of generality. It is through the identification of the appropriate level that the ratio decidendi is discovered. For example, if you have two cases involving road traffic accident, the agent of harm in both is the vehicle, for example. That's where you try and find commonalities. When you're looking for reasoning among different judges, there'll obviously be a majority and a minority. So for example, if you have 5 judges and you're given a number of reasons, so they all prepare the judgment, they all have reasoning. When you read them, you see that the same reasons come up for 3 of them, and maybe the same reasons come up for 2 of them, so 2 become the minority and then 3 become the majority. That's basically what happens, and that's why there's always an uneven number, like 3 or 5. Now let's just have one more look at the obiter dicta, because this is the non-binding part of the judgment. But they are of persuasive authority. This therefore works both ways, because a court might adopt a proposition of law it has identified as being obiter, or it might decline to adopt a statement of law on the grounds that it is obiter. The weight or value of it depends on a variety of factors, including the court in which it was delivered, the reputation of the judge who delivered it, the precision with which the point was expressed, and how it has been dealt with in subsequent cases, and finally its closeness to the instant case. It's also important to note that stare decisis is sufficiently flexible to allow for the development of rules through the process of adjudication. So basically what that means is you have to understand that the law progresses outside of courts and life progresses outside of courts, so there needs to be some flexibility around older rules. Otherwise the system will be greatly weakened. So finally, the next day we're going to go through legislation in Ireland and what the legislative process is, which is very important for anyone considering constitutional law at any stage. It's also just important really for lawyers, to be honest, just to know what goes on, and I am looking forward to seeing you in that one.